Good morning, everybody, and welcome. My name is Hanson Borders, Managing Partner of Mauldin and Jenkins, and we are pleased to present this webinar on the recent stimulus package, the CARES Act, signed by President Trump this past Friday. Joining me today for the presentation is Jonathan Hightower and Kevin Strawn from the law firm of Fenimore, Kay, Harrison & Ford, and my fellow partners from Mauldin and Jenkins, Jeff Fusito, Ryan Enlow, and Carl Garner. The CARES Act has several stimulus components consisting of the widely publicized SBA loan program called the Paycheck Protection Program, but also includes various tax and payroll tax incentives. It is important that you contact us or your tax advisor to discuss all the available stimulus options under the CARES Act, as some tax incentive programs may not be available if the SBA loan programs are pursued. Our presentation today will focus on the Paycheck Protection Program and its requirements. My understanding from the many interactions I have had about this program is that it is unlike any government stimulus and incentive program of the past. Small business is the bedrock of the American economy, and this pandemic has shaken that foundation. With this program, Treasury looks to stabilize this segment of the economy by supporting and sustaining small business payrolls. It will also hopefully provide significant stimulus to the economy for a very quick rebound once we get to the other side of this crisis. In the past, some of you may have been reluctant to pursue government-backed programs such as this, or they may have been unavailable to you. But these are very different times. I encourage you to strongly consider these programs, and we can help you do that. With that, I will turn it over to Jonathan to review the program, and hopefully there will be time for each of us to answer a few questions for you at the end, and we will certainly answer any follow-up questions after the conclusion of the webinar. Jonathan?
Good morning. Thank you, Hanson. Glad to be in front of you guys. I know it's a really stressful time in a lot of ways, and this Paycheck Protection Program is designed to help with that. But of course, you've got to understand it before you can take advantage of it. Just a couple things to emphasize as we get going here. Our firm, Fenimore, Kay, Harrison & Ford, is a boutique banking firm. So we have spent countless hours, frankly, over the last week or so helping our clients work through this program, understand what their role is, how they're going to be asked to participate. What we had intended this morning, given that so many of you joining the webinar are small business owners, is to give you the ability to understand the program from the bank's perspective so that you can go in and present a clean application that can be processed efficiently by the bank. And I think that's still our goal today. But as many of you may be aware, Treasury just issued some guidance yesterday afternoon that really muddied the waters in a lot of ways for banks as to how they're to administer this program. So I think a big picture theme from all of this is banks are being asked to do something they've never done before on an extremely short time frame without a lot of information. So know that many of you are going to have questions coming into this call that we simply can't answer because the answer doesn't exist, or at least hasn't been published. But what we do want to do is go through the knowns that we have in the program, give you some action items to help you understand both what you're eligible for and how you can plan a use of the cash that you hopefully will receive in your business to be able to get forgiveness. We're going to do that at a fairly high level because, again, this is a 900-page stimulus bill, and we're going to talk for about 45 minutes and then take questions. And we'll try to address as many of those common questions as we can. It looks like we have a little bit more than 1,200 people with us right now, so we're probably going to get more questions than we can answer, but we'll do our best. With that, let me turn it over to my partner, Kevin Strawn. Kevin's been practicing with me for the past decade. He's done a great job in digging into the details of this program. He's going to go through the slide deck that we've prepared for you. I'll jump in with color where appropriate, and we will take it from there.
Thanks, Jonathan. So first, we're going to talk about an overview of the loan program. I think an important thing to keep in mind here is that although it's characterized as a loan program, the expectation is that almost all of the quote loan proceeds that the banks fund to individual borrowers are going to end up forgiven in just a couple of months. So if you're thinking about taking this as a loan, most likely, and we'll go through the, all of the requirements for forgiveness, but most likely you're going to be able to get most of that loan forgiven in very short order. And then to the extent that you have any of the loan left over, that'll be a 2-year loan on very favorable terms. And we'll go through the specifics of that later. All right, so first thing, we're going to talk about a good example with actual numbers just to kind of help you kind of frame this. And then we're going to go through who's eligible, the maximum loan size, and all the details of the program. Okay, so first off, we'll spend some time on this. This is a very simplified example. As I can see from all of the questions that are coming in, most of you have far more specific questions than this, but this is just, in a very simplified case study here. So if you're an eligible borrower, you have an average monthly payroll of $150,000 per month for each of the last 12 months. You apply for the loan with your bank. So you reach out to your bank. Your bank may or not be participating. So if your bank doesn't participate, your bank can probably get you in touch with one that is. You have to attest that the COVID-19 is expected to impact your business operations. And then you submit documentation of that $150,000 per month. Now, you can take out a loan of up to 2.5 times that $150,000. So in this example, that's $375,000. And we hope that that'll be able to be funded in relatively short order. But again, banks are going to get a lot of these requests all at once, and they're operating with uncertain guidance so far. So hopefully we'll get some more guidance to allow banks to push that money out to the borrowers in a relatively short order. So you've got $375,000 in cash and loan proceeds. Over the next 8 weeks, if you incur $350,000 of eligible expenses, and eligible expenses include those same payroll costs that make up the $150,000 per month, but also utilities and interest and rent. After 8 weeks, you submit that documentation to your bank. The bank then in turn submits that to the SBA, and the SBA will forgive all $350,000 of that loan. The end result is that the borrower is left holding only the difference between the $375,000 in loan proceeds and the $350,000 in forgivable expenses they submitted to their bank and then to the SBA. So that's just a $25,000 loan due over 2 years, only half of 1% interest, and you have no payments due for the first 6 months of the loan. So as you can see, as I was saying before, this just emphasizes that while it's characterized as a loan, the reality is that most people are going to end up with a really small piece that is actually a loan at the end of these first couple months, period.
Yeah, just a couple things to add on there, just from a practical standpoint. Here again, the Treasury guidance that has come out, or the SBA press release, gave an example of someone being able to walk into their bank on Friday and get approved the same day. There may be instances of that occurring, but from a practical standpoint, the volume of these applications is not really going to provide a reasonable opportunity for banks to properly assess the documentation and get an approval the same day in most cases. From what we're hearing, representing as many community banks as we do, and I also serve as general counsel to the Georgia Bankers Association, we're not aware of any banks that are saying they won't have a way to facilitate this for their customers. So I think as a small business owner, huge likelihood that your existing bank is going to be able to assess and fulfill your needs in one way or the other as it relates to these loans. But don't think just because they don't give you a same day approval that you're going to have a better situation elsewhere and that will be commonplace. Again, time will tell. Banks are going to get more guidance and they'll get better at this as this goes. But our view is that Treasury and SBA did not set a realistic expectation for small business owners in that regard.
All right, so the first question, who is eligible for a loan here? And first of all, if you're familiar with the 7A program, if you have expectations about who can and cannot participate in SBA, this really wipes out those previous expectations. This is kind of a whole new regime. It's a lot broader, so it's going to be a lot more inclusive. The general rule here is business concerns with fewer than 500 employees. So any business with fewer than 500, including nonprofits, veterans organizations, tribal business concerns, which is again, pretty broad. And there are the SBA has some peculiar rules about counting franchises and things like that. And they've done a lot of relief that we'll get to later. But the real nice thing here is that it also allows, sole proprietors, self-employed, and independent contractors to participate. And that's where we're getting a lot of the questions, and understandably so. But the headline story here, though, is that if you're self-employed, or if you have borrowers who, they're sole proprietor, they should be able to find a way to participate and benefit from this program. It was designed to benefit them, and they were not overlooked here.
Yeah, here's another place where, certainly wish we had more specific guidance. There are a lot of churches in the South, a lot of churches that are not able to meet and collect offerings and are facing some degree of peril. Generally, churches aren't eligible for SBA programs. We've seen a bit of guidance here saying they will be eligible for this program. I sit on a church board, and I can tell you we are getting our application ready. So the normal SBA rules in a lot of respects aren't going to apply to this program. It's meant to be broad. It's meant to keep people's employees making money. With that said, there are some peculiar restrictions within the statute that banks are having to grapple with.
Yeah,
Jonathan, I might comment briefly on that. We're getting a little bit of information in regard to churches that the non-secular activities, so let's say that the church has a daycare provider, that would qualify. And if the church has other types of activities that are not the secular type activities, that it seems pretty clear that that would qualify.
Yeah, I agree. I think that part is certainly the easier part. The piece that I was hoping to get more clarity on is just the general sort of payroll, as that term's used in this program. Again, that's just not out there right now.
a couple other eligibility things, and we mentioned there are a lot of different rules here. First of all, there's no loan that's too small. I mean, I think these are going to be from sole proprietors who are talking about they make a couple $1,000s a month, all the way up to some really large companies that have hundreds of employees in each multiple locations. So we trust that banks are going to try to work with even those small borrowers. There are some I think, like I said, banks are looking out to help people. There's going to be some more processing for those smaller borrowers, especially with the 1099s. We're looking for more guidance there, but don't think that you're too small to participate in this. As we mentioned before, you're going to have to certify that you've been affected by this, which I think is real easy for a lot of businesses. If you think about a restaurant that has been even closed by government order, that's very easy. For maybe larger businesses that are still having some operations or still functioning 75% is normal, that becomes a tougher question. But I think most businesses will be able to make that certification without too much trouble. SBA usually has requirements for a lot of their programs that say you have to certify that you're unable to apply to obtain credit elsewhere. That's gone here. You don't have to make that certification. You do have to have been in business on February 15th of 2020. For most businesses, that should be relatively easy to show their bank, but that is something that banks are going to have to certify. And then there are a lot of new rules for businesses of, for the 500 employee count. There are a lot of exceptions and a lot of workarounds, particularly if you're a hotel or a restaurant. I think the bottom line there, those rules are complicated and we're still looking for guidance there. If you think that you're affected by the 500 employee rule, that's really where hopefully you're big enough there to have some professionals that you work with regularly who can help guide you through that. And again, hopefully they'll be able to guide you through some future guidance because it's not 100% clear as currently proposed.
Yeah, one other piece on the application itself, if you reviewed that document, it's got a question on there that goes to, do you have overlapping management with other businesses? Just know that for many of you as small business owners, you do have maybe controlling interest in several different ventures. The bank is going to have to get behind that and determine if there's an issue with the general SBA affiliation rules. There's a big carve out in this program for hotels and for restaurants, but it still applies in many cases. So again, when you think about processing time, if you're applying and you've got a series of businesses, the bank's just going to have to work through that with you.
Okay, and that goes to the next question of where can I get a loan? Again, if you have an existing relationship with the bank, I would start there. Hopefully the bank where you do most of your business will be able to provide that. But if not, we expect that even banks who decide not to participate directly will have partnerships set up, and they'll be able to point you somewhere where they will be set up to give you those loans. Yeah, the application, the form that came out yesterday, again, as Jonathan mentioned before, they've created some expectation that you can submit that Friday and that banks will be ready to go. Looking at it from the bank's perspective, as we do, because those are our clients, there's a lot of uncertainty about what, the SBA is telling them to get the money out, but not necessarily giving them all the tools they need to do that. So we're going to have to kind of wait and see exactly how long that'll take, but we certainly hope that this will move pretty fast.
Yeah, we had a question pop up earlier with someone who does most of their business with a credit union, asking if credit unions are available to participate. The program does allow credit unions to participate. We're not very familiar as bank lawyers with credit unions. My general understanding is, their focus is much more on the consumer side. So I'm not sure how they'll be able to execute in this program, given that they may not be as familiar with that. But they certainly are eligible.
Okay, next up we talk about this first math problem, and that's determining the maximum loan amount. So again, the general rule is 2.5 times your average monthly payroll cost, and payroll cost is a defined term in the statute, and we'll get to that next. So you basically take what you spend on payroll for 1 month, you get 2.5 times of that, and that's the size of the loan. There are exceptions for seasonal employees, and there are exceptions for companies that weren't in business for all of 2019. They're allowed to use a kind of a stub period from 2020. So next up, we'll talk about the elements of payroll cost. And there's a long list. I would characterize this as they've made it pretty broad. There are some uncertainties around the edges, but I think it's it's generally pretty broad here. It's obviously salaries, includes commissions, and then they have this similar compensation line. Cash tips are included. So if you want to pay your tipped employees, if you want to pay them that, you can count it on the forgiveness side. We'll talk about that later. Payment for leave, severance payments, premiums for health insurance, taxes on the compensation, and then there's a $100,000 limit on employees, which makes sense if you think that the program's not trying to pay out for the high salaries. There's a question as to whether that $100,000 is capped at the salary level or at the total compensation level. We heard on a call this morning from SBA some guidance that the SBA thinks that's going to be a limitation on salaries, which is certainly good, both in that can increase the loan size for you and that reduces a little bit of the complexity where you're not going to have to go in and calculate total comp for each of those highly compensated employees.
Yeah, a couple things to think about here. Again, on the small business side, there are issues with your ability to substantiate this. And the bank is required to make a maximum loan amount calculation. The bank is going to be on the hook if they get it wrong. So again, we would stress to any small business owner, as much careful documentation of these items as you can possibly have is going to facilitate your application moving more quickly than it otherwise would. Now, you've probably got some questions that we just can't answer, either because the guidance hasn't addressed it, or just how would you document the tips that your people have received. They're probably not coming to you and waving them in front of your face. And that's just an open question.
Yes. And another open question, as we mentioned, sole proprietor, self-employed, and so forth. You're not going to have that 941 that you can show your bank. And so that's going to be where again, looking for further guidance as to exactly what the documentation requirements for that's going to be. Obviously, if 1099s are helpful, but you've got, it can be the net income or net earnings of that small business. And this is another thing that comes up here is this is the one thing you can really do right now is start getting this in order. Get your 941s together, get support for items that weren't on the 941s, but that are included in this list here, and have that ready to provide to your bank as soon as the applications can be accepted. Okay, so what can you use the proceeds on? The first line item, which is going to be the largest for most everybody, are those same payroll costs we just talked about. So, the maximum loan amount is based on 2.5 times the payroll costs, and then you've got that large chunk of money, $375,000 in our example. But for many small businesses, it'll be a much smaller. And the first thing you can use it on those same payroll costs. You can use it also on utilities, rent, and on existing mortgage debt. Utilities and rent are also, there's a requirement that those were existing. I think it's in February of 2020. So you can't go out and, they're basically trying to help you maintain your current level of spending. You can't go out and try to get a new loan and pay down that. You can't pay principal. It's only interest on mortgage debt. So it's a little broader what you can spend it on than what the maximum loan amount was calculated on. And that's because, you got 2.5 months when calculating the maximum loan amount, but these expenses, you're only going to be able to, you're only going to be able to count them for forgiveness for an 8-week period. So the math's a little funny there, but it does make sense. So that's why it's a little broader in what you can spend the money on than what the loan was based on.
Yeah, here again, the guidance yesterday had a new expected requirement in it, and that was that 75% of the forgiveness amount is expected to be in payroll costs and not in the utilities, rent, interest categories. Again, the way the program is set up, that math is just going to naturally work for most of you. But do keep that in mind as you present your forgiveness documentation or sort of model out how this may benefit you.
Moving on to the best part, and that's the forgiveness. So for those payroll, rent, utility, mortgage interest that you spent during the 8 weeks after you received the loan proceeds, you collect that documentation and then you send it back to your bank. And then the bank forwards that to SBA, and subject to the next couple slides we'll talk about with some limitations, you should get dollar for dollar loan forgiveness on all of those documented expenses that are eligible. The one other thing on this point is that when you're sending that documentation to your bank, they're also going to ask you about the number of employees that you have during this period, and that'll come up in the limitations in a couple slides.
Yeah, to emphasize here, and this is critical if you take nothing else away from this presentation as a small business owner, the way the program is set up, and again, subject to further guidance, the bank is not going to have any wiggle room on the documentation for this forgiveness. So please keep good records. We've had people ask if they should set up a segregated bank account just to be able to track how this money is used. It's not a bad idea. But detailed records, probably well beyond even what the most sophisticated finance department would normally keep. Have your canceled checks, your ACH confirmations, whatever it may be. Again, I know when most people take these loans out, they're not really planning to repay the principal. So we don't want to get you surprised at the end, because again, the bank is not really given any sort of flexibility to take your word for it or to trust you on this.
Okay, this first limitation on loan forgiveness, and this is really behind the whole point of the program. The goal here of Congress in passing this was to give small businesses funding to prevent layoffs, or to the extent that layoffs have already happened, to have those small businesses bring those people back until everyone expects the economy to get going again. So for that reason, they're going to look at the employees during the reference period, which there's some complicated rules there, but it's essentially, the average number of full-time equivalents you had for a period back in either 2019 or earlier in 2020. And there's, again, special rules for seasonal employers, but they're essentially going to look at the number of employees you had back then before this all happened, and the number of employees you have during this 8-week period for which you're receiving loan forgiveness. If you've reduced the number of employees, say you went from 10 employees during the reference period to 8 during the 8-week period, you're only going to receive 80% forgiveness for those documented eligible expenses that you submit to your bank. That's the tough part here. I know a lot of borrowers are going to be kind of impacted by this sort of without having done any layoffs, and that's just kind of tough. The loan, this whole program is a bit of a blunt instrument, and there's going to be a lot of situations where you look at it and you're saying, oh, that's kind of unfair. I got, that the law worked out this way for me. But, again, Congress just, they wanted to pass it to make it as quick and easy to get money out as possible. And, we see all the questions, and this is one area where some people are going to get caught up, even though they haven't had any layoffs or anything like that.
Yeah, we've had some questions about, well, what about people just resigning? I mean, probably not the smartest move from a career standpoint during this point, but there will be instances of that just for a variety of reasons. Again, no clear guidance on that, but I would expect that to be addressed in clear fashion. I wouldn't expect you to be penalized just because someone voluntarily resigns. We've also been asked about, okay, well, what about just salary reductions? Can I do those? Again, that's not really the idea behind the program, but Kevin's going to cover the limitations around that right now.
Yeah, that's the next slide right here, is that for those employees who are earning less than $100,000, if you've reduced their wages more than 25%, there's going to be a reduction in your forgiveness. So, and again, that's consistent with what you're seeing a lot of big businesses do, is they're having the highly compensated employees take a pay cut, sometimes voluntary, sometimes not, a pay cut, but they're trying to preserve those for the sort of rank and file. Again, it's 25%, so there is some, I don't think they really want you to. And remember that you're going to get reimbursed dollar for dollar here. So I think for most businesses, it probably makes sense is to maintain them at their current levels.
Yeah, the idea that you're seeing rolled out a lot in professional services, particularly the law firm world, is we're going to suspend partner compensation for a period of time, and then we're going to take everyone else down by 10 to 20%. Nobody's going beyond 25, and this is the reason why.
Yeah. So the next slide, which we had to add yesterday afternoon, is based on that Treasury guidance yesterday, and that just says, John mentioned before, that they're expecting forgiveness to be limited to 25% for the non-payroll costs. So for your rent, utilities, mortgage, interest, for most small businesses, that may be capped at 25%. Now, that doesn't mean you shouldn't submit those costs. You should certainly track them and try to submit them. And if you submit 120%, support for 120% of what you can actually get forgiven or what your principal amount is, that's the best you can do. So no reason not to try to claim everything you can. All right, next up, and this is some good news as well. You have the ability to rehire employees or to raise salaries again. So there's two kind of rules there. One is you have to do this by June 30th. And again, we don't know exactly when loan proceeds will be funded, but the other timing rule is you probably want to do this prior to receiving the loan proceeds, just to maximize the payroll costs that you can document during that 8-week period so that you can maximize your forgiveness. If you hire someone back halfway through the 8-week period, that's probably just going to reduce your forgiveness below the level you could have taken. And you're going to end up having to pay that back to a loan in the loan over 2 years when you could have just paid your employee for a few more weeks. All right, so those are the terms of forgiveness. We talked about how you calculate, how you document forgiveness, and then some potential limitations. Now, after the forgiveness amount, remember in our example, we had $375,000 loan proceeds, $350,000 forgiven, and a $25,000 loan on the back end. That $25,000 will be a 2-year term. No payments are due for the first 6 months. Interest rate is only 0.5%. No prepayment penalty, no personal guarantee, no collateral, and there are no other fees for the loan. So the SBA is going to pay the banks a small fee upon origination of the loan, but there's nothing that the borrower has to pay, no origination fees or anything like that, either at the beginning of the loan or after you get forgiveness and this gets rolled into a loan. So again, we expect for most small businesses that they're going to be able to document 100% forgiveness and they're going to walk away with no loan. We think that for some borrowers, you are going to walk away with a relatively small loan, and obviously these are very generous terms for that small piece. Yeah,
one piece here that's a little tempting. Again, the way we had understood the program prior to yesterday, we expected to see a 4% rate on this money, which is, in today's world, that's market or maybe even a little expensive for some of you. Here at 0.5%, this is cheap money. So I think one thing to think about there is even if you aren't able to reach the maximum forgiveness amount, these are good terms on which to borrow, especially the lack of guarantees, the lack of collateral. But just caution you to not take that too far. Remember, you do have to give a certification that you intend that you need the money, and that there's an intent to maintain the payroll. That's the purpose of this program. So don't think, well, I'm actually just going to keep my business closed down and just take this money because I might need it eventually. Again, that's not really what it's for, and we certainly wouldn't want anyone delivering a certification that wasn't true.
That's right. And we talked about, I said right here, there's no personal guarantee and so forth. The two places where they have said, they are going to look at that. One is obviously fraud. If you're submitting false information to your bank, false information goes to the SBA, either to support that maximum loan amount or to support forgiveness. They're going to go after fraud for sure. The other piece, though, is that they're going to go after, you do have personal recourse if you use these for unallowed purposes. So we mentioned before what the forgiveness standards were for. Remember, payroll costs, rent, utilities, mortgage debt. If to the extent that you have a loan at the end of this, you also have to use the proceeds of that loan for those same amounts. So if you have an ongoing business, that's not going to be hard. It's pretty easy to document. Again, in that $25,000 example we gave, it's pretty easy to show that over the next 2 years you're going to use $25,000 in aggregate on payroll, rent, utilities, and mortgage debt. You are actually allowed to, the one allowed use that's not included in forgiveness is non-mortgage interest. So that's just one little quirk in the law that I suspect someone just missed, but really it's going to be, you should, in tracking that, I don't know that everyone's going to go back and, hopefully not get audited on that exact point, but it is a good idea to the extent that you have loan proceeds to do some documentation on the back end that shows, oh, I had the $25,000 in loan proceeds and my payroll was, $15,000 in August and $15,000 in September. So I exhausted that $25,000. I've satisfied the loan conditions in that I used them all of my use of proceeds were allowed. All right, next slide, documentation. I know this is where we've got a ton of questions, and unfortunately, this is where I think banks and borrowers alike are really looking for a lot more guidance. Exact requirements have not been published. We do know that 941s are going to be the best document in many cases for supporting that maximum loan amount and for supporting the bulk of your forgiveness request. It gets a lot trickier for smaller, businesses, sole proprietors, self-employed, 1099s, and things like that, where they're talking about their net income or net earnings. I know we've got a ton of specific questions here, and there's not a whole lot more specific that we can get. Hopefully, maybe Mauldin and Jenkins can in the Q&A, but this is going to be where the rubber hits the road, and where there's going to be a lot of back and forth, and the banks are going to have to do a lot of manual, checking of your documentation.
Yeah, I think one point, again, just to maybe re-emphasize, this is still the early innings for this program. Treasury has more or less demanded that it begin immediately and that money start to flow out to small businesses. And obviously there's a great need for that. But there will be more clarity on it, we hope, in the coming days, but certainly in the coming weeks. So as we sit here, looking at 250 questions and counting, the answer to many of those questions is we don't know yet, and no one knows yet. And I realize that's frustrating. It's frustrating for the lenders. It's frustrating for the small business owners. But that's really where we are. Again, these are unprecedented times. So you wouldn't normally see banks rolling out a brand new product where they really don't even know what the terms are. But yet here we are. So we'll learn a lot more as we go along. Again, I think particularly from the small business owner standpoint, understand everything that there is to understand. When you have a specific question, ask your professionals. Your CPA is a great resource on a lot of this because they presumably got a lot of your records. But I'd caution you against just assuming you understand the intent of the program and that you're happy to submit a certification on those assumptions. We saw one comment pop up just a second ago, and I think it's an important one. The application emphasizes that it's not just the business making the representations in the applications. it's also any 20% owner of the business. So again, when Kevin talks about that personal recourse, all the major owners are involved in the application as well. So attention to detail is going to be really important in a variety of respects as we move forward with this program. With that said, it's not meant to be the biggest challenge in the world. This whole program exists so that the money can flow out into the economy and replace some of what we're losing.
That's right. And a couple, again, on a more positive note here, you know, some of these traditional SBA limitations, I think we've addressed all these we've gone through, but no collateral, no personal guarantee, and no requirement that you show that you can't get credit elsewhere. There are a few other SBA programs in the CARES Act. The first one, which is actually really nice, if you have an existing 7A loan, there's a 6-month period where not only is it deferred, but they're actually saying that amount's forgiven as well. So, you know, and I think there's a lot of debate about whether that is going to start on the payments due today, April 1st, or whether it's going to be next month. I know that as of last night, they hadn't figured that out yet, but certainly the intent of the law was that there'd be no more payments this month. So that the details you have to work with your bank on, but that's a really nice piece of it. The Express Loan Program, if you're familiar with that, they've had a temporary increase. Those are for larger loans. 7B disaster loans are available. We've seen a lot of questions on this, and it is very confusing. The way the statute read essentially was that if you already received an emergency loan this year relating to coronavirus, what they want you to do is go out and get a PPP loan, and they'll increase that PPP loan by the amount of that existing disaster loan, and then they will repay the disaster loan. They also said that you are not. There was also in statute, it says that you should not apply for a disaster loan after the PPP loans become available. And they become available as soon as April 3rd. And my understanding is that banks are saying if they're not in now, it's kind of too late. I don't want to give you an answer one way or the other and tell you that you can or cannot apply for disaster loan and a PPP at the same time. Maybe Mauldin and Jenkins can chime in if they have a view. I think it's just a little, that's one of the biggest questions on this right now. I do think that, one option is, I think certainly the intent of Congress was that to push people to the PPP to the extent that they have to cover their payroll cost. That's the first thing. And then if there are emergency disaster loans, maybe you can go back later and apply for that for non-payroll costs. And it also needs to be, costs that are not going to be included in the forgiveness, which would be rent, utilities, and so forth. And then of course, if you may have seen is that even if you apply for a 7B disaster loan, you get $10,000 in 3 days as an advance. And if you are ultimately denied that loan, you get to keep that $10,000. If you get the $10,000, it reduces any forgiveness from a PPP loan. But that's, again, where it gets a little complicated how the two work together. And I think there's a lot of conflicting information out there.
Speaking of conflicting information, we just had a question pop up regarding the measurement period for your payroll costs. And again, we're sort of ignoring new businesses, seasonal businesses right now. That's a tough question at this point because the statute very clearly says it's the 12 months prior to the loan being made. The application says for most companies, the year 2019 will be sufficient to substantiate that number. I can't tell you why those two things are different, but they are. Yeah.
So, and again, there are special rules for seasonal and special rules if you weren't in business. I know it's easy enough. If you weren't in business, you're allowed in all of 2019, you're allowed to use January and February of 2020. But if you started business at some point in 2019 or, based on that question in the form, it's a little tricky. So that's the end of the sort of slide presentation. You want to turn it over to, I think, Hanson here to start leading it, kick us off on Q&A.
Thank you very much, Kevin and Jonathan. Very, very informative. And so at this point, we'd like to take a few of the questions and hopefully provide you with some good answers here. So I'm going to turn that over to Jeff Ucita to steer us through that. Thanks.
Okay, thanks, Hanson. I'm going to echo a few of the comments that have already been made about the fact that there's a lot of information that's not yet available, and hopefully we can answer these questions the best we can. And there's some general ideas that you just have to keep in mind through this process. And I've got the application up on my screen. And one thing I'll point out, and this was kind of interesting to me this morning. So the SBA now on their website has put this application up, and they're using sample wording. And And then if you go to open up the application itself, it's got a big sample stamp over the top of it. If you go to the Treasury Department website, it does not use sample wording and does not have a sample stamp on it. So I think this is just another example of, this might still be open and this could potentially change possibly, and they're still trying to figure out some of these things. So I just wanted to point that out. And then Jonathan, I think you did a really good job of mentioning the certification, because conceptually, this certification on this application covers some concepts that we have to keep in mind, through this process. And I noticed a number of questions in here that kind of led to this concept. The very first thing you have to be careful about is that you're attesting to the fact that current economic uncertainty makes this loan request necessary for you to support the ongoing operations of your business. So before you do anything in regard to this application, you want to be able to attest that that is the case. And then I noticed a number of other questions in here that were asking about what the funds could be used for. And if you read through the certification, that's the very next thing, that it's making you certify that this money is to be used to retain workers, maintain payroll, make mortgage payments, lease payments, utility payments, and anything else is really an unauthorized purpose. And then it gets into, we've got a lot of, Jonathan, you're once again pointing out how important documentation is, and that's the very next certification, that you're going to maintain certain documentation regarding a payroll cost and these other items that are covered in order to substantiate the use of these proceeds. So I think we just need to keep, first of all, the certifications in mind, and then try to work through these details as much as we can. So the first question that we have, we can be certain about this, is how are you going to receive the materials? And we're going to send out an email to the participants that will have a link to the video cast and then also the PowerPoint presentation. So you'll have both of those in the email that we'll be sending out. And then in addition to that, there will be a link on the Mauldin and Jenkins website for these materials. Let's see. There's some general questions in here about are they allowed to change the terms of the bill? And I'm going to let an attorney answer that.
Well, the answer is no. The Treasury nor the SBA has the ability to change the law. Now, I think we have to allow for a couple different things. One, they had all this thrown on them just like we did. So mistakes happen. My guess is in the application they made the mistake. And we'll see if that gets corrected or not. On the other hand, I think particularly from a banker standpoint, there's been a lot of questions about, wait a minute, we thought we had a 10-year 4% loan, and now we're talking about a 2-year 0.5% loan. This is where the lawyers will catch you, because the statute itself says a loan with a term up to 10 years, a loan with an interest rate of up to 4%. Now, I'll confess, when I read particularly the interest rate piece, my belief was that banks would choose that interest rate, and that 4% served as a cap. I did not expect Treasury to come out and say, here's the rate. But that is what they have done.
Okay, there's a question that's actually a good question. I've had to remind myself of this a few times myself. The question is, the form has a box for payroll. Do you add the other items to that box? So remember, the concept here is that you are applying for a maximum loan amount, and that calculation is strictly using payroll times 2.5, an average monthly payroll times 2.5. And that's going to be the loan amount. Now, how you spend that money is not just on payroll. It includes rent and mortgage interest and utilities. And those are two separate things. So the reason why the box only includes the payroll calculation is for that reason. And that's why it's 2.5 times, because they're not just taking the payroll, they're adding this 0.5 times to cover the other costs that we talked about, with an expectation.
Jeff, I think you will also see that the average monthly payroll box is going to include things other than wages, because there's other things that get included in that. So I expect that there will be some reconciliation process between the 941s or however you document the wages. There will be other things that you get to add to that to be included in covered payroll costs.
Right, and that's I think this was addressed in our presentation earlier. There is some debate, and it sounds like you might have gotten some clarification, Kevin, this morning, maybe more from SBA on this about the $100,000, because there was some debate whether the 100,000 included benefits, at the cutoff, or if it did not. And we've seen interpretation both ways. And what did you hear this morning on that, Kevin?
Yeah, what I heard this morning, which was also not definitive, but the indication from the SBA was that they think it's going to be, the $100,000 cap is only going to be applied to salaries. So the reduction is only going to be to the extent that you have salaries for an individual employee over $100,000, and you won't have to go in and remeasure the total comp for each of those employees. So that was some good news, but again, also not 100% certain from the SBA.
Okay. Is the webinar eligible for CPE? And it is not eligible for CPE. There were certain things that had to be put in place for that, including where we would have to poll you and have you answer questions. So that is not the case. So this is not eligible for CPE. There are a number of questions about sole proprietors, and we've talked about that very vaguely, and unfortunately, there's not a lot of guidance on this now. Carl, I don't know if you have any input on that we haven't received yet in the presentation. Or maybe other area.
No, here I am. There, at this point, there is a provision for self-employeds up to the $100,000 limit. As far as the documentation, I think we're going to have additional guidance on that.
Okay. Once again, I know some of these answers are going to be a little bit vague, but we're just waiting for more clarification on a number of these. And there's a number of questions that came out regarding, can you do the P3 and the disaster loan? And I've participated in several sessions now related to this program and have heard varying interpretations, but the common theme that I am hearing is that you can't get both of them and use them for the same thing. So there could be a way, and I think this was mentioned also, that you receive the P3 proceeds, you spend that money down over your 8-week period of time, and then you also receive the disaster loan proceeds and then use that for your longer term needs. And I was on a Georgia Chamber call yesterday, and David Perdue was on the call, and he was describing conceptually the intentions of these programs. And the intention of the P3 program was to get people back to work, or to get people paid, through this 8-week period of time, to get us, through what's hopefully the worst part of this pandemic. And the primary intent of the disaster relief loan program, might be a longer term need. And we have a number of clients that, even though the pandemic might end, in the, May, June time period, their business might not really be able to start up in any real way until much later in the year. And they're going to have a need for these disaster loan proceeds to enable them to open up their business and enable them to do what they need to do between now and then to survive. So I think two different purposes, and I'm hoping that there isn't anything that prevents people from using the benefits of both of those loans. Any comments on that? And Jonathan, I know you were talking about this earlier, and Kevin, so there's definitely some uncertainty here too.
Yeah, just one piece, and I'll turn it over to Kevin to sort of talk about the two programs. But I think you're also touching on an issue that's come up with our clients having questions about businesses giving the certification when their ability to meet payroll for the near term and really to continue their operations over the near term is not at issue because of the sort of lagging or trailing nature of their collections of their receivables. So they're going to have plenty of cash flow coming in for the next 3 months, but the fact that they're not really producing right now is going to hurt them maybe even as late as third quarter. Again, our firm belief is the intent is to be able to support companies like that and keep them from making a decision now to lay off employees in order to preserve cash for that looming event. With that said, it is important to sit down with your professionals, with your bankers, talk about your specifics vis-a-vis that certification and make sure you feel good about delivering it. There's lots of talk about criminal penalties in the statute. I don't see anybody going to jail over a difference in view over what that very vague standard means, but that's out there. So I'd just say, again, be considerate and mindful of what you're signing. Don't just throw it at your banker and wait for your check.
Okay, there's another good question in here that we've been pondering ourselves, and the question is rent paid to a related party includable? And then there's an additional question, for triple net rent, are all the cost, insurance, and property taxes includable? And I'll make a comment on that and just see if anybody else has any additional input. This is one of those things where we just do not know. In my opinion, common sense tells you that it should be includable as long as it's arm's length and comparable rent, to what you would pay to a non-related party. But this is just, I can't find anywhere where this has been defined beyond just rent. Does the panel have any comments on this?
So under the statute, rent means rent. The term covered rent obligations means rent obligated under a leasing agreement in force before February 15th, 2020. So, I understand that paying taxes and insurance are a part of your overall occupancy costs. But again, based on the guidance that exists today in the law that's out there, it is just the rent portion of that payment that's being covered.
And Jonathan, any opinions on the related party rent?
Not
very common.
Yeah, getting that question a lot too. We don't have any different point of view from you. We haven't seen any guidance that prohibits it, and it makes sense to us that rent that's contracted in good faith, consistent with market, arm's length, all those nice adjectives should qualify. Again, there's so much ability to abuse this program in general, and that's one prong of it. I think you certainly want to be careful and conservative in how you apply for forgiveness from the government.
Okay, there's a general question more surrounding unemployment, and I think the point is when you apply for forgiveness, you have employed individuals, and you're using that compensation as part of the forgiveness formula. So if you have unemployed individuals now, and I don't know if you watch many of the newscasts that occur every day, and they've been stressing, yes, you can bring them back to work and use these P3 funds, to support them, over the period through June 30th, and even if they're unemployed currently. And I have a number of clients who are doing that will have unemployed staff, or until they receive the loan proceeds, or they're unemployed now and they plan on bringing those back when they get these proceeds. Any comments on that from the panel?
I certainly think that was the intent of the rehiring provisions, is that employers would do that. Again, you have to think about, and I know it's hard for all of us to project in the future what your business is going to look like in the 8 weeks after you receive the loan proceeds, but and certainly consider how the unemployment benefits versus the salaries, how that is going to impact each individual employee. And those are just going to be tough calculations to make, but certainly the intent is to encourage you to bring them back and get forgiven for that amount.
And this is kind of beyond the scope, I think, of this session that we're doing, but the unemployment question, now that we've got the additional $600 benefit, it could make much more sense than it used to, where you can still take care of your employees by them utilizing this new $600 unemployment benefit, and then receiving these loan proceeds, and then from that point on bringing them back and and then, paying them that way. So that the $600 in addition to the existing state unemployment benefit is a big difference. Georgia maximum unemployment benefit was somewhere around $330, $350, and you add $600 on top of that. That's a big difference versus the previous maximum Georgia unemployment benefit. There's a number of questions in here about 1099 contract employees, and this is, Kevin, you talked about this a little bit already. There's, in my opinion, a lot of uncertainty surrounding this question, and the once again, the session I attended yesterday from the Georgia Chamber made a point that it really has to be W-2 employees that are reported on a 941, and the reason that was given for that is that 1099 contract employees can actually apply for this P3 assistance themselves, so they're not being left out, and then you as an employer are using your W-2 salaries for purposes of the loan provision, the loan calculation. Any comments on that?
Yeah, I think there's uncertainty in the statute itself as to whether an employer can include in its payroll costs 1099 payments. I think there's some support in the statute that they can, but what you mentioned earlier and what we're kind of hearing is that was not the intent. And I do think that there's a duplication of benefits problem if that is if you read the statute that way. So, and again, this is very much evolving and this may change, but I think right now maybe we can view best practices as if you have 1099 contractors, encourage them to apply and encourage them to apply and send them the link. Hopefully they can work with their own banks. And hopefully they can get their own loan and you can kind of handle it that way.
I think that's the best advice we can give right now, because the statute, I don't think they meant to say what they said in the statute, because it certainly can be read to allow a clear opportunity for a small business to get proceeds and keep paying a 1099 independent contractor. But it's also, clearly it allows for those independent contractors to get their own loan. So again, just to restate Kevin's point, I think the best thing as an employer that you can do is highlight for those independent contractors their ability to get a loan through their bank and support themselves in that way.
Let's see. Any amount unforgiven, the question is any amount unforgiven still guaranteed 100% by the SBA? And my interpretation of that would be yes.
Yes.
And that's one nice thing about this program. No guarantees, no personal guarantees. This is kind of, I think it's just good to reiterate this concept again, but the question is wondering if you have to prove loss of revenue or a possibility of layoffs to receive the loan. And once again, you've got to go to the certification, and the verbiage we have now is that there's a current economic uncertainty that makes this loan request necessary to support the ongoing operations of the applicant. And that's what we have now. And I've heard a lot of discussion about this because it's very general and kind of big picture. Does anybody have any comments on this?
Yeah, the bank is not required to verify that you've suffered any revenue hit. That's not part of the bank's underwriting. The bank is just required to collect that certification from you, and that's it. So it's really a self-certification, and no one right now at least is going to be going back to look at your numbers to make sure that you've actually suffered any loss.
We talked about what the money can be used for. Any questions like this, just go to the application, and it's just a good source where they've summarized some of that. Does this cover an owner of a subchapter S corporation salary and up to the $100,000 limits we discussed? I would say yes, it does.
Yeah, the employee is defined differently for these purposes than you might see it elsewhere. If you're working there 40 hours a week, even if you're an owner, you're considered an employee for this purpose. I don't think your bank's going to come and look at your timesheets or the clock that you've been punching either. So, good faith.
there's an affiliation. I'm not going to read the whole question, but there's a question that basically is kind of getting down to an affiliation question. And this was mentioned earlier in the presentation too, but there's some existing rules in regard to that SBA has in regard to affiliation. And I had to read them the other day, and honestly, I was a little bit surprised at how broad it is. And the basic rules are you can be affiliated based on ownership. They define ownership as 50% or more of another concern's voting equity. You can be affiliated based on management, and that's kind of a general catch-all for a lot of our clients. You know, so if you have common management of multiple business entities where they exercise authority and control over those entities, that can create affiliation. You can have affiliation based on identity of interest transactions. And without getting too technical, identity of interest transactions consist of economic kind of interests that you might have in a business, you know, where one business is relying on another economically, and that ends up creating an affiliation concern in this case. And then there's some other guidance that I won't get into, but you have to be careful in regard to affiliation for these limits that they've set on the number of employees. And it's something you want to look at definitely on an individual basis, depending on your circumstances.
Yeah, we've seen that question a lot, and you know, keep in mind, this is not a rule that's intended to say if there are multiple businesses under common control, then they're automatically eliminated from the program. That's not the idea at all. It's intended to eliminate abuse. You can imagine a big conglomerate that has 100 different subsidiaries, each with 50 employees. That's not the type of business this program is intended to serve. Just know that even though I would imagine most of the people on this call, even if you've got affiliated businesses, they would all comply with the rules and be eligible. Your bank is going to have to look at that and take some time to consider it. So again, it's just going to take some time to work through the process.
Question about how do you determine if the loan's forgivable? And once again, you would need to spend the funds on these purposes that you're certifying when you're receiving the loan. And one comment that I made earlier to Kevin was you can apply for these loan proceeds, receive these balances. I like the idea, I think that I don't remember which one Jonathan or Kevin made about segregating the funds, because that way you can control the use and track the use for its appropriate purposes. And then worst case scenario, for whatever reason, your payroll dropped or something that, you know, might have limited the forgiveness, and then you pay it back. And, you know, that's the worst case scenario. And I think that's kind of a good way to think of it, especially if we have some uncertainties, you know, through this process, but hopefully those will be clarified soon.
Yeah, and you pay that back. That's again, a 0.5% loan over 2 years. Yeah, we don't know how that's going to amortize, if that's going to be interest only or amortizing or what, but regardless, it's going to be, you know, better loan terms than you can find just about anywhere else.
There's a question about employees being U.S. citizens or not, and how do you certify that? And, you know, the guidelines that we're using now are having more to do with payroll and, you know, what's been on your 941s. And then that comparison will occur for the forgiveness. So I think that I haven't read anything about I-9s or anything like that. The only thing I've read has to do with just you're certifying that these are employees.
Same here. And I don't think that's going to be a part of the due diligence. Keep in mind, if we have any international companies on the call, this isn't intended to support the payroll of those outside the U.S. But that's the only limitation that comes to mind.
And I don't remember if this point was made earlier, but we can make it now. It says, can we apply for both payroll protection and disaster relief through our banks? So the payroll protection loan is through your bank. Now it's SBA 100% guarantee, but this is going to be, you've got to go to your banker and you have to apply through your bank. Disaster relief is directly through SBA. So two different processes, and at the moment, in my opinion, they're very similar processes. If this doesn't change from what we've got now, they're both fairly simple applications and pretty brief.
And the application form asked you if you have an outstanding SBA loan, an outstanding disaster loan, and if you do, I think they're going to try to roll that loan into this, and then that gives the form, at least again as Mark's sample that we've seen, says, did you have a loan between January 31st and April 3rd, 2020? So that's what's supporting our view that they're hoping that people will not apply for disaster loans after April 3rd if they're going to also apply for the PPP loans. But again, that's very much up in the air right now, and don't take that as is the last word on that just yet.
One thing I'll throw out there, and I don't remember where I saw this, but I saw a time estimate of 8 minutes to prepare the application. Did you guys see that?
No.
Yeah, so.
Well, you certainly could do it in 8 minutes. I just don't know if it'd be right or not.
Yeah, that seems a little bit quick. Okay, and what happens if revenues stay fairly intact after taking the loan? Will that change loan forgiveness? So I'll let you guys comment on that.
Yeah, this is about uncertainty and about keeping people employed. And again, there are some issues with the language around that, but one thing that they got right is they're not going to go back and look to see if you ended up being okay. They just want to keep you from laying off people because you're not sure. So you don't have to feel bad if your business ends up doing okay through this.
How do we submit the application? What documents will be required? So once again, contact your banker, and they'll walk you through it. And for now, fill out this application that we have, gather the information that you're anticipating your banker needing, in particular, your payroll documentation, and anything else that they're going to request, and be ready. And hopefully these applications can go in very soon. Let's see.
Hey, Jeff, there was a question earlier on the cap for this program. I'm hoping that maybe Jonathan or Kevin can also comment on this, but the current cap is $349 billion, and I believe that was derived from some payroll data that the SBA or Congress used. But is there any thought as to whether that will be increased if the cap is exceeded in short fashion?
So, here's some rank speculation pieces, although I think it's speculation coming from people who know what they're talking about. I've heard the same, that this number was not just pulled out of thin air. It was based on looking at payroll data or estimated payroll data for companies eligible for this program. With that said, the way this program is designed, with certain banks being given delegated authority to approve and fund these loans before they present to the SBA, I don't practically believe there is any way that Congress could let this program run out of money prior to June 30th. There's too much risk in it for the private sector if they were to do that. That's been backed up by some comments from legislators saying, look, this is the easiest thing in the world for us to appropriate more money to. We know this program is successful when it's used up. That's what we want to happen. So some of the guidance that Treasury put out yesterday was not very helpful in reassuring people that the money will be there for them if they apply timely. With that said, that's what we believe. On the other hand, it's certainly understandable if you don't want to take that risk.
So Carl and I were actually talking about this yesterday, and I think, Carl, you found where there's 30 million small businesses in the US. And if you do the math, if everybody applied for this, it'd be like $11,666. You can get on your calculators. I might be wrong about that, but this question has been coming up a good bit, and we've heard other comments from people in Congress that there would be additional funding for this if it ran out. But of course, that's just comments, so we don't know if that's going to occur or not. One question that just popped up on the screen that I'll answer, that's kind of an easy one, is asking if car allowances are part of this. And What is part of this is W-2 wages, that is on your 941s, and car allowances do go in box 1 of your W-2. So yes, that's taxable compensation, just like any other type of compensation. So we're down to 3 minutes. Do any of the panelists have any comments or anything they want to add based on everything we've talked about? And there is a significant number of questions that we, of course, could not get to. So we're sorry about that, but we're available as a resource. And then just please look online on the SBA site in particular and in other places, to get answers. But for the participants, any just general comments?
No, I think that's the big thing. This program is intended to be a benefit to small businesses to support you, throughout this difficult period. But do make sure you get it right. Don't think that if you spend 10 minutes instead of 8 on the application that's too much. Pay attention to detail. It's going to be important. I think particularly as you look down the road several years from now, when we look back on this program, you don't want to have any concerns about whether you did it right or not. So take your time, obviously move as efficiently as you can, but make sure you get the details correct.
And just be patient with your banks. They, like I said, we represent banks. We're helping them interpret these rules just like we're helping you on this call. They're trying to get the money out as fast as they can to their customers and help their customers stay in business and keep their employees employed. But they're also trying to do it without taking on, undue risk. And frankly, the law as written includes a lot of vague terms that banks are going to be taking on risk if they interpret one way or the other. So until they get more guidance, they're going to have to be very careful about what all they can do to help their borrowers. But just know that's what they're looking to do, is help their borrowers as quickly and as much as they possibly can.
I'll tell you one thing, guys. I don't know why I was thinking 11:15, but actually we're set to go through 11:30. So I was premature in cutting this off. Hopefully we didn't just lose 1,000 participants on our call. All right, so I'm gonna go through and we'll cover a few more of these questions for you. There's a number of uncertainty questions and what's considered to be uncertain, and I think Jonathan, you answered that pretty well. And we're not thinking that requirement is going to be anything more than what we've read already and anything more stringent. And they're really just trying to get money out into people's hands to get through this crisis. Let's see, nonprofits. And Jonathan, you mentioned this earlier. So the P3 program is available to 501c3s, 501c19s, and then certain tribal organizations. 501c19 organizations are veteran organizations. The EDIL loan is not limited in that regard. And so just to be clear, 501, and I think I saw a question here about this, 501c6 organizations are not included, in this P3 loan. And there was one interesting question that I actually see a good bit where a nonprofit had a foundation or a second entity that wasn't technically the employer, and they were sharing employees in the other related nonprofit. And they were wondering if in the other entity, it was a C3 versus the entity that was employing the individuals was a C6, will that qualify them for this P3 loan? So it seems to me like that should qualify. But I'm using the word should. Whether it would or not, when we get more details on this is another question. So any comments on that?
Nothing to add.
And there's other situations where organizations, nonprofits and for-profits have an arrangement, where the employees are not technically paid, by the company. They're paid by another entity, and then they're basically contract employees. So hopefully that will be addressed, because it's not an uncommon situation, and it seems like those employees should be able to be included, even though they technically do not have a 941, from the business or the, the organization.
Yeah, I think it's just going to be very important that you work with those other organizations to make sure that you're not both applying for the same, to duplicate benefits. I think as long as you're steering clear of double dipping, I'm hoping that there won't be any, they won't be coming back and trying to, claw back anything like that. I think avoid double dipping is really the watchword, and that's all we can do until we get a little bit better guidance on some of those points.
All right, there's a question. The 941 will not show employees that make over $100,000. How will the bank separate this? So once again, when you're gathering your payroll data, you're going to need to segregate the employees that make over $100,000 and cut them off at that. And I would assume the banks are going to want to see that information. And it's just part of what you're going to have to gather in addition to the 941. So the 941s are not going to be the sole source of information that I would assume the banks are going to need to prove out the number for payroll.
Yeah, it's difficult because even your ADPs of the world aren't breaking that information out in their reporting. So there's going to have to be a manual adjustment, maybe a separate spreadsheet that you use to back those people out. Now, how's a bank going to want to get behind that? Are they going to want to see, individual W-2s and whatnot? Probably not. But again, they haven't been given any guidance from Treasury as to how carefully they have to study that.
Let's see. Are part-time employees covered for payroll? And yet, yes, they would be part of this payroll calculation. Once again, anybody who is in your payroll at the moment, if you go off the application instructions for the 2019 year, would be part of the calculation for the amount of the loan. And there is another question in here, so we probably ought to just talk about this one more time about the variation of what we were thinking the bill was saying in regard to the year prior to the loan origination versus what's in the application being the 19 years. So you might want to maybe Jonathan or Kevin mention that again.
Go ahead.
Yeah, it's frustrating. The statute talks about a 12-month period prior to the loan being made. The application talks about most companies being eligible to use 2019, and I can't reconcile that for you. I think because almost no small business owner will go and read this 900-page stimulus bill. They're going to be relying on the application. That's perfectly reasonable. I expect banks will have to get comfortable with that at some level. But again, we would love to see Treasury or SBA either correct its mistake or issue guidance that gives banks a safe harbor to rely on that information.
There's kind of an interesting question about annual retirement contribution for employees. It's paid in March of each year for the previous year. Can we accrue these costs monthly for 2020 and count that money as part of the payroll payments we're making during the 8 weeks? And my gut tells me that you probably could not do that. I think they're looking to get money into people's hands that they're giving you through this P3 loan, and that's what will count. Any comments on that?
I would agree with that, but I also agree that it's, I don't think that's, 100% going to be the case. They may come back and change that interpretation.
There's a number of questions about are banks allowed to apply for a PPP loan? And I haven't seen anything contrary. Any opinion on that?
Yeah, so this is to speak to the banks in the group right now. There's nothing out there saying that they can't. That is contrary to the normal 7A position where banks and other financial companies normally aren't eligible for the program. But again, that's just one of several ways that this is not a normal SBA program. The caution that I would give the banks on the call, as well as any other businesses that find themselves in this situation, think carefully about that certification. It's really hard to give for a well-capitalized liquid business that is encountering earnings challenges, because clearly there's uncertainty Clearly, getting a forgivable loan supports your operations. The question is it necessary? Because I don't think anybody's questioning a bank's ability to continue its operations from a financial perspective right now.
Okay. I read a question when I was skimming through earlier that I think is worth us addressing, because I've heard this a few times. It was about if individuals quit, does that hurt your calculation? And everything that I've read, this is not based on individuals. So let's say that somebody quits today and you hire somebody tomorrow. You're still going to have these salaries that will go into your calculation for the forgiveness of the debt, and it's not individual specific.
Yeah, I agree 100%. What they're looking at is in the example in the presentation was you had 8 employees before, now you have 8. Sorry, you had 10 employees before, now you have 8. What they're looking at is just the FTEs for the reference period versus the FTEs for the 8-week period following loan origination. So, there are going to be a number of reasons why your number of FTEs change, and that's, the purpose is to increase the number of FTEs you have during this 8-week period, and then hopefully beyond. But the individuals can come and go. You don't get, if someone quits versus getting laid off, that's just kind of tough. They still want you to go out and hire someone else if you can. I know that that's not always the easiest thing in the world, but that's again one of the ways in which this is just sort of a blunt instrument and is not going to have perfect results for everybody.
And there's a number of questions about varying expenses. Like I just saw one about rent. If the landlord defers the rent that you owe, could it still be eligible for this forgiven period? And Kevin, I think I agree with you that we'll have to wait to see how some of this is interpreted. But once again, if you just go by the idea of this whole thing, they're trying to get this P3 money into people's hands so that you can go out and spend money in our economy. And it seems like that's what would be forgiven, but we'll have to just wait and see how this turns out. Any additional comments on that?
I think you'd have to pay it for it to be included in forgiven, the forgiven portion, which I think also means if your landlord says, hey, I'm going to try to help you out and defer rent, you might say, actually, I'm going to go ahead and pay you this amount because you anticipate, because you'll get forgiveness for that amount. And that's although it sounds like kind of an odd result, that's the whole purpose, is to keep money flowing even to your landlord in addition to your employees.
On the other hand, just in case anyone's wondering, you cannot accelerate rent.
Right.
Okay, I think we'll just wrap up the questions with that. And once again, now I want to give the panelists an additional opportunity just to make any comments, anything you want to point out, and then we'll let Hanson wrap it up for us.
Appreciate being on. Really enjoyed being able to speak to everybody this morning. I think big message in all of this is stay tuned. There will be more detail coming out. At least I certainly hope so. And again, just appreciate the time this morning.
Yeah, thanks, guys.
Okay, Hanson.
Okay, well, once again, thank you everyone for attending. Particularly thank you to our panelists, Kevin, Jonathan, Jeff, Ryan, and Carl. So we will be sending each of you a recorded presentation with the slides, and that will also be available on our website, mjcpa.com. Our contact information is also available in the slide deck. Again, please carefully consider these stimulus options, very important to the economy, and let us know if we can assist you in any way. Thank you so much. Good day.
All right, thank you.